Hello, I'm Scott Fulton, President of the Environmental Law Institute, and it's my pleasure and privilege to be part of this important conversation at the 2018 World Water Forum about the role of environmental rule of law in helping us meet our water quality objectives. I thought I would spend my time looking at one of the success stories in the United States context, and that is controlling industrial discharges under our Clean Water Act. And I'll do that in part because it offers a really good illustration of the power of environmental rule of law. I'll then compare this experience with another water quality challenge in the United States, and that is controlling surface water runoff, again looking through the lens of environmental rule of law. So let's start with our rule of law framework. In the United Nations system, we generally think of rule of law as having two related but distinct elements. First, that law be inclusively developed and be consistent with fundamental values and protective of fundamental rights. And then second, the idea that the law is observed in fact, in practice, by those who are covered or affected by the law. And these two elements are interactive in the sense that when law is consistent with fundamental values, when it is protective of fundamental rights, then it's more likely to be accepted, respected, even embraced by the community affected by the law. And the reverse is also true, that when law is not reflective of fundamental values and rights, then there will be difficulty getting the affected community to comply with it because they won't respect it and therefore will not observe it. Now, the experience that the world has had to date in the environmental context allows for a more granular understanding of what needs to be present for these conditions to set up that allow for rule of law. And we look in this regard to the decision that was taken by the United Nations Environment Program's Governing Council back in 2013, Governing Council Decision 27-9. This is a very important instrument because it was the first intergovernmental instrument to use the word or phrase environmental rule of law. And in that decision, which was a consensus statement by the world community, it was observed that environmental rule of law is multifaceted and depends on the presence of the following interactive facets. First, implementable and enforceable law. Second, public access to information. Third, public participation guarantees and rights. Fourth, accountability in fact for environmental decision makers. And that includes both governmental decision makers who are making decisions about what can happen and where and how, but also decisions that are made in the private sector. And that accountability for government is typically produced through judicial review of government decisions. Accountability for the private sector is produced through enforcement, again, principally through the courts. A fifth element or facet is effective resolution of disputes, principally through the judiciary. A sixth is this idea of government coherence, that programs be approached in a way that is coherent and efficient. Coherent both vertically through the different levels of government, but also horizontally across the same levels of government. And the seventh and final element is the idea of some sort of independent review mechanism that helps keep government honest in its implementation of programs. So this is the learning from this Governing Council decision and the 7 facets that allow for environmental rule of law to emerge and take hold. So let's take a look at that framework as applied to the industrial discharge problem in the United States. First, a little context. The United States is a country that, like many countries in the world now, went through a period of rapid industrialization without proper regard for the environmental consequences of that development, and was in a bad place in the 1960s leading into the 1970s. There's a river, a major river that runs through the middle of the United States called the Cuyahoga River. Runs right through downtown Cleveland, Ohio. That caught fire not once but 3 times in this period of time. Very difficult to put out because this was a chemical fire that occurred on the surface of the water. Lake Erie, one of our precious freshwater Great Lakes in the United States, had been virtually ruined by this time beyond the point of use. Again, all of this was a function of rapid industrialization without an environmental protection mindset. So in 1972, the Congress of the United States took up this issue and passed the Clean Water Act of 1972. There had been some laws on the books before then, but this really was the signature moment for water quality protection in the United States. It's noteworthy that this legislation passed the United States Congress with an overwhelming majority. In the United States Senate, it passed 74-0, and in the House of Representatives, it passed 366-11. And this reflected the strong societal fundamental values consensus favoring recovery of the nation's waters with the goal of making them once again fishable and swimmable. So let's look at how this law, this Clean Water Act of 1972, squares with our environmental rule of law framework, starting with facet 1, this idea of implementable and enforceable law. There were some features of note built into this law with the intention of enhancing implementation and enforcement that I'll mention. For example, some features that facilitated implementation included a process for national water quality assessment and standard setting for every major water body in the United States. So goals were attached to the recovery of these rivers and streams and lakes. Second, the creation of a national permitting system for covering these industrial discharges across the country. Third, an orientation focused on pipes, discrete conveyances, what we call in the United States point sources. So where wastewater is being collected and discharged into a receiving water, looking at that point of discharge as the point of regulation. There was some utility in that when water is harnessed in that way or concentrated in that way, it is monitorable. You can evaluate what's in the water and better anticipate what the impacts on the receiving stream will be. But it also means that the water is being collected and can therefore be treated. So it also allowed for treatability of this wastewater. The law also set up a dual standard setting mechanism for permits, so that when permits are issued to industrial sources, they're expected to both meet water quality standards. So this is looking at the water quality of the receiving stream and extrapolating from that what the character of a particular discharge should be, but also required the application of best available technology. So there was a technology driver that required a permittee to apply the best available control technology, but also this requirement that at the end of the day it also needed to meet the water quality standards. And this is some of the magic that was built into this law. There were some features that were also designed to facilitate enforcement, including the idea that permittees would self-monitor their discharge and to file so-called discharge monitoring reports on a regular basis that would self-identify any exceedances of permit limits. So these DMRs, as they're called, ended up being a very important feature of this architecture. The law also allowed for per day, per violation penalties. So penalties of great consequence could be amassed in these cases and assessed against violators. It provided for criminal penalties for intentional misbehaviors, but also for false reporting to try to make this DMR system have integrity. It included provided that civil violations could be enforced by government and by civil society alike, which was a very important feature of the law. And it also provided in the statute penalty guidelines to inform how these penalties could be assessed and guarantee that at a very minimum they would ensure that the economic benefit of noncompliance was recovered, so that violators would be worse off in violating the law than they would be in waiting to get caught. The second facet, access to information. The law provided for public access to permits and all of the documents that form the basis of permit decisions, and also public access to the compliance databases maintained by the state and federal government. This means that citizens had the basic information needed to participate in both the permitting and the accountability process. And regulated entities were likewise given access to this information. In addition to the Clean Water Act rights to information, the Freedom of Information Act came along in the United States, which provided an additional basis for accessing this information and much more. And all of these information access rights were set up as enforceable rights through action in the courts. Our third facet, public participation. How does that look under the Clean Water Act and industrial discharges under the Act? There's a right on the part of the public to be given notice of proposed permits. There's a right to comment on permits, a right to appear at public hearings relating to permits, a right to challenge permits in court, rights to sue those who violate their permits or operate without permits, pretty much the full complement of public engagement rights. Facet 4, accountability. A strong tradition emerged under this legislation for vindicating the rights and remedies established by the statute. Government has been held accountable through judicial review petitions by citizens and permittees alike, challenging the permit decisions made by government. And those decisions have been overturned often enough to help guarantee integrity of government decision-making. Violators have been held accountable through a combination of government and citizen enforcement action. There are some important enablers that have allowed this accountability system to set up and take hold. One is just the question of resources. There was an investment by the United States government in governmental resources for enforcement work and monitoring work in this area. Investments to set up a data system for monitoring compliance and the like. It's very difficult for this work to be done without that kind of serious commitment. Another important enabler was the development of some other legislation called the Equal Access to Justice Act, which provided that citizens groups would be allowed to recover their litigation costs and attorney's fees if they were successful in the matter that they had brought forward. This allowed citizen groups to capitalize effectively the litigation that they were bringing under the Clean Water Act, which was a very important contributing presence under this program. Facet 5, this idea of effective dispute resolution, principally through the courts. Under the Clean Water Act, courts meted out tough remedies against industrial discharge violators, reflective of the societal values embedded in this act. So penalties recovering the economic benefit of noncompliance and more. Aggressive schedules for returning violators to compliance. Jail time for intentional violators or false reporters. The courts also added to the law effectively through their jurisprudence, offering judicial interpretations of issues not clearly addressed by the statute. So, for example, it was the courts that held that the liability that obtains under the Clean Water Act is strict liability, drawing on the common law principle of strict liability for ultra-hazardous activity. It was the courts that provided that these DMRs, these discharge monitoring reports, should be treated as unimpeachable admissions against interest, so that violators could not say they were inaccurate in what they reported. No, the courts held that the DMRs would be treated as prima facie proof of a violation. And this then allowed for the issuance of summary judgment decisions by the courts. If the DMR showed that there was an exceedance, there almost unquestionably was liability, and the question of liability could be resolved through summary judgment. So the courts were an integral part of the evolution of this program. Facet 6, institutional coherence. There were mechanisms in the statute that have been further elaborated on through governmental policy that intends this kind of integration that I was talking about before, vertical integration down through the column of government. So there's consistency between what the federal government is saying it wants to see happen, what is actually happening through states that are being taken by, decisions that are being taken by states and the like. There's a system for delegating authority to the states so that instead of there being both a federal permit and a state permit, there would be a single permit that would be administered by an approved state. States were also given the first mover option for enforcement purposes. But that said, the federal government reserved authority to take action if the state failed to act or acted insufficiently. There also were horizontal integration mechanisms, a memorandum of understanding with the Department of Justice who would bring enforcement actions in court so that the process for investigation running through prosecution in court was seamless, well coordinated, and integrated between these two elements of the federal government. And that was secured through a memorandum of understanding, which is a very useful tool for working through these coherence questions. Finally, facet 7, this notion of independent review, some system to make sure that the government is making decisions that are grounded in integrity, that aren't influenced by corruption or other externalities that would cause those questions, those judgments not to be sound or in the public interest. Here, there were some other developments. There was a development of standards of conduct for employees of the executive branch of government that attached to the performance of environmental professionals. That made it quite clear what could and could not be done. There also was the establishment of a of an investigation function, something in our system called the Offices of the Inspector General, that made those standards of conduct quite real. If there were allegations that they'd been violated, this was an independent element of government that would investigate those violations and hold people to account who were determined to have not honored the ethical obligations of their office. The net of this was that that corruption within governmental implementation of this program in the United States is simply not a factor, again, thanks to these tools. The net result of all this is a dramatic reduction in surface water impacts from industrial discharges, huge gains in water quality in the United States, non-compliance coming to the point of being very low, and that, of course, means ultimately fewer enforcement actions, which is the case now, that is reflective of enhanced and continued compliance. So when I look at this, what I see is a success story by just about every measure. Why? And I think it's because the basic tenets of environmental rule of law have been observed in this context. Now, let me compare this briefly with another water quality challenge in the United States where we have been less successful. With the industrial contribution largely addressed, non-point source pollution or stormwater runoff stands as the primary unaddressed water quality challenge in the United States, with agricultural runoff in particular being a major contributor. So the gap between where we are now and the Clean Water Act's goal of producing fishable, swimmable waters is owing to this problem of non-point source runoff. In contrast, with all of the strength that was aimed at industrial wastewater pollution in the Clean Water Act, the non-point source architecture is quite weak. Indeed, federal or national control only occurs indirectly through a system that requires the federal government to develop a list of impaired waters or waters not meeting water quality standards, and then develop a water body specific assessment that allocates pollution loadings to the source community that, if followed by the state, would allow the water body to meet its water quality standards. These so-called total maximum daily loads typically include an allocation for non-point source pollution. But there is no clear mechanism to enforce if the state does not follow through. Indeed, very little of the structure that I have described relating to industrial pollution attaches to the non-point source universe. So, walking down our environmental rule of law ladder, there are poor data generating features which impacts public access to information. Although total maximum daily loads can be challenged in court, there are otherwise no more localized decisions to which public participation rights attach. There are effectively no accountability measures under the statute, and no accountability in fact, except when states are self-directed and wish to take action and have the legal authority to do so. There's not much for the courts to take up in this space. Institutional coherence is problematic because no one is clearly in charge or accountable. So from a rule of law standpoint, it is dysfunctional. Looking a little bit more deeply, what is behind this dichotomy between the industrial source community and the agricultural source communities. Unlike point sources, runoff is not discrete. It cannot be so easily seen, cannot be so easily collected or treated. And the solutions that attach to non-point source pollution are not so much about water collection and treatment, but rather about land management best practices. And as a result, the water quality interest runs right into a values conflict with the values that are associated with traditional livelihoods, with farming being perhaps the most sacred traditional livelihood of them all, and with farmer freedoms and privileges relative to how they manage their property, competing with the societal interest in better water quality. You add to this a powerful and organized farm lobby that accentuates this values conflict with legislatures and government officials, and you have what we have on this question, which is nothing really to comply with, no rule of law framework, and very little progress. So I trust that you see clearly this contrast that I'm drawing between these two examples. The first, this framework for industrial wastewater discharges, which is grounded in rule of law principles and has worked and worked well, producing dramatic improvements in water quality. And the second, this framework for surface water runoff, which is not built on rule of law principles, really has not worked, and explains why our water quality efforts have at this point plateaued out and are not making the further progress that we would desire towards fishable and swimmable waters. So I will bring my talk to a conclusion here. I hope that I've illustrated the importance of the presence of each of these facets of environmental rule of law in accomplishing success in an important program like water quality protection, and more generally the pivotal role of rule of law in delivering water quality goals. Thank you.